and welcome back to the Brian Fagan YouTube channel. I'm Courtney and today we'll be discussing a critical topic in Texas family law: how to get a divorce based on abandonment in Texas. Abandonment is one of the recognized grounds for divorce under Texas law, but it's important to understand the legal requirements and the process involved before proceeding with your case. So let's break it down and walk you through how abandonment can be used as a grounds for divorce here in Texas. First, let's define what abandonment means in Texas divorce law. For abandonment to be a valid ground for divorce, your spouse must have left you with the intent of abandoning you, and they must have been gone for at least 1 year. Simply leaving for a short period of time does not constitute abandonment here in Texas. There has to be a clear and intentional desertion. The abandonment must be without your consent, and your spouse must not have made an effort to return or to reconcile during that time. Proving abandonment isn't just a matter of saying your spouse left. You will need to provide evidence that shows your spouse intentionally abandoned you. This can include testimony, documentation that shows they've been absent for over a year, and possibly even evidence of any attempts they've made to avoid contact with you. If they've moved away and haven't returned for any meaningful period, this strengthens your case. If you've decided to pursue divorce based on abandonment, the first step is filing a petition with the court. You will need to state the grounds for divorce in your petition, and in this case, you would cite abandonment. You'll also need to prove that your spouse has been gone for at least a year and hasn't made efforts to reconcile or return. Once the petition is filed, your spouse must be served with divorce papers. If you don't know their whereabouts, you can request the court's permission to use alternative methods to notify your spouse, such as publication or publishing a notice in a newspaper. One of the significant aspects of an abandonment-based divorce is how it can affect property division and spousal support. In Texas, the courts typically divide marital property equitably, which doesn't always mean 50-50. However, if you can prove that your spouse abandoned you, the court may decide to award you a larger portion of the marital estate as compensation for the hardship caused by the abandonment. Additionally, spousal support may be affected by abandonment. If the abandoned spouse has been financially dependent, the court may award spousal support to help them recover from the impact of being left without financial assistance for an extended period of time. While abandonment is a valid ground for divorce in Texas, it's important to weigh your options carefully. You can still pursue a no-fault divorce if you don't want to go through the process of proving abandonment. Additionally, if you have children, you'll need to address child custody and support issues during the divorce proceedings. The court will prioritize the best interests of the children, and abandonment by one parent can influence custody decisions. In conclusion, divorcing on the grounds of abandonment can be a complex process, but it's an option for those who have been left by a spouse for more than a year without consent or support. If you find yourself in this situation, it's crucial to gather the necessary evidence and seek legal advice to ensure that you can navigate the process smoothly and protect your rights. Thank you for watching. If you found this video helpful, please remember to like and subscribe to the Brian Fagan YouTube channel for more insightful family law topics. We're here to help guide you through every step of your legal journey. See you in the next video.
Thanks for tuning in to the end. We understand that divorce can be expensive depending on the situation. That's why we're offering our Do-It-Yourself Texas Divorce e-course. You can get access to this e-course by clicking on the link in the description below. Catch you in the next video.